home sale, or more. I mean, up to half the real estate commissions. This is easy if you're referring clients to the listing agents. There's a process that we talk about where basically you could be getting up to half the listing agent's commissions for your work, for the work you do. And I've mentioned that in other files. So over here, I have a list of the things. Let me just go over the list, all the things an attorney could or should be doing on the file. So it's up to you. Like in the past, before I get to the list, in the past, you might have referred, you did the work, you developed a client, you're doing trust and estates or family law. Sometimes with probate stuff, you're not, because of that schedule, you're not really even making as much money as the realtor. And I know, I mean, I've had referrals that attorneys are thinking, hey, I should be getting half of this referral. But many are aware that that would be an illegal kickback under RESPA if the buyer's got a loan involved. And the California Bar Association saying you can get referrals, but it has to be for the work that you do. And so this is really the breakthrough. My point is, because I'm an attorney and a broker, I've sold 200 homes, and I'm telling you that attorneys are now needed to do at least half the work on these files. So it's up to you. You can do the work and you can get paid. I have no problem justifying right now, if you even help with buyer agent compensation negotiations, you counsel the client on the risks, and you help mitigate. So basically, let me just go over. You're going to counsel on the 3 risks. There's really 4, but there's 3 that were brought up in the class action suits, and that's steering, compromising the fiduciary duty of the buyer's agent, and price fixing, commission fixing. Myriad ways to mitigate those risks from probably 100% down to substantial. You should counsel your client on this. When the offers come in, you find out how interested your client is to selling to that buyer. Like, are we starting in the right price range? Are there other offers coming in? Are showings happening? Are properties selling, or are there just more coming on the market? Like all that market temperature, combined sellers' desires, how many hoops they want to jump the buyer through. Then you devise the mitigation plan. And as I'm saying, you get substantial to 100%. Now, realtors cannot do this. It's super valuable because all those class action suits, the 1.6 billion, if you look at the forms in the process and what the DOJ said, warning that it hasn't really changed, it's all just been shifted to the sellers. It can be mitigated, should be mitigated. Realtors can't do it. In fact, realtor forms and process are causing the issues. If your seller just sold without any buyer's realtors and buyer's commissions, they'd be fine. They could even switch the process and avoid it. But the process the California Association of Realtors are using, I see it as just taking the risks and sticking it on the sellers, and they're not even telling their sellers their process cannot help them sell for more. So that's the second thing, leveraging buyer agent compensation. We'll go into this in the past because it's really part of how to sell a home for top dollar. But just the idea that realtors are no longer leveraging buyer agent compensation to get the realtors representing the most motivated buyers at the time to come to the property at that time. They're leaving that part of the strategy out. It's, I believe, responsible for the softness to some degree we're seeing in the market. I mean, there's other reasons too, but it's weird that for 10 to 15 years, even in the short sale market, there were multiple offers going on, and consequently sellers could, negotiate hard and maybe even get through the offer. And in many areas that's disappeared. It's not just the economy. It's not just the market. It's the process. Realtors cannot do what they used to do. Sellers can still do it. Attorneys mitigating the risk for the sellers could then work with realtors, and they can all still do it together. And attorneys could do it on their own. Attorneys, you're licensed to sell homes. You're just not necessarily licensed to get a percentage commission. That's the rule. That's the law. That's why there's all sorts of ways to make sure attorneys get paid 50% on these files, if that's what an attorney wants. I'm talking about in this course, just like $10,000 straight up. And someone who sold 200 homes, I'm telling you, the work you do is worth $10,000. Now, so now the next part, responding to the request for buyer agent compensation. Realtors have this little blank form for a counteroffer, and they're supposed to choose the language. Right there, I think they're violating SIPR. If they choose to respond on that contract, again, that's a choice because they could respond with 2 contracts. Absolutely a violation of SIPR. SIPR is quoted by the DRE, and it stands for the fact when realtors practice law without a license, that's a criminal violation. I don't see how realtors can be responding on blank forms, drafting language, and when that choice really should be. And the car knows this because they used to have a little magic box that talked about real estate commissions, and somehow it was magically not part of the transaction, but on the contract. Now they're with this third-party beneficiary clause. It's somehow in the contract again, but it really should be broken out. It would help the sellers every time if you break it out to leverage buyer agent compensation to get a higher price and to at the right moment, if necessary, negotiate buyer agent compensation down after they've already agreed in principle with the buyer in terms of the price and the other details regarding the sale of the home. Why not save it? I mean, if your seller's happy, they got good top dollar, pay the realtor for doing the work. But if they're negotiating hard and you're not getting the net you want, that should remain open. And the proper way to do it is to bifurcate. In fact, there's so many reasons why I just don't think you should have two contracts running into these little boxes with realtors doing the work. It's an abomination for sellers, and it seems to just be practicing law without a license and breaching their fiduciary duty. And when they set it out and they break it out into two, you can also mitigate the risks of price fixing, of compromising the fiduciary duty of the buyer's agent, which is like, if you've read the DOJ and the class actions, realtors are still doing that on every file. They're passively letting their sellers do something so easily mitigated. And also steering, that's built into these forms. I've discussed that in other videos. Now, that's just part of it. I think right there, that's $10,000. Realtors can also help on disclosures. They should be doing disclosures. Disclosures right with the right process can encourage more offers and higher price offers. You do the disclosures ahead of time. You make them available. Those disclosures are not just as you would recommend your seller do it. You actually would say, well, this is what your responsibilities are. But I would disclose these extra things just because they're going to see it when they walk through the house. And when they see it, they're going to relax. They're going to realize your client's not trying to pull a fast one. They've got disclosures. They've got the repair report. And they see the problems. You'll mention the crayons on the back of the door. And all of a sudden, you're going to start getting more offers and top offers. That's what lawyers can do. There's contract review. There's closing and title problems that come up sometimes. There's requests for repairs that create problems. And there's closing because of lender issues. Working with attorneys, I'm going to tell you how to deal with lenders who do their little quality checks a few days before closing and try to blow up They don't blow up transactions. They screw sellers. And I can tell you from experience how to deal with that, because it was happening with a good friend of mine once. And the woman and the buyer moving in, the woman was pregnant. They're sitting in the truck. The furniture's outside. And they're crying, and the lender's not funding. I mean, those are tricks that lenders do to mess up sellers. So all of that is very important. Attorneys are, in my opinion, and there's ways to do it. In this course, we're talking about like $10,000 worth of work. But there are other methods I've worked and set up in the past where non-broker attorneys can set up the files. Actually, they can set up the structure, so that they're entitled to 50% of the listing agent's commissions. And again, this shouldn't be money coming out of your seller's pocket. This should be paid for by the listing agent out of their fees, their customary fees. I mean, if you negotiate them down to $5,000, I'm not expecting to be able to pay a lawyer out of that. But if they're getting 2.5% or 3%, the lawyer should be getting paid. My name is John McConnon. I'm a broker and attorney in California. My website's listingattorney.com. I've got a couple of great ways to work with attorneys in San Diego and surrounding areas, or really all over the state of California. And I can help you come up to speed so that you're entitled to that $10,000 on every file as well. Thanks. The series is ongoing on Facebook and YouTube and maybe other places soon, but you can always find out more and probably see this video series at listingattorney.com.